All right, friends, we do have several clips to look at in this video, but before we get to any of that, we're going to do something so much more fun than watching clips. We're going to do some reading. We're going to read excerpts from the Supreme Court decision because it really is interesting. As a reminder, though, here's the situation. This is the culmination of the various constitutional challenges against Donald Trump's eligibility to become president, or really to hold any public office at all. The argument is that Trump violated Section 3 of the 14th Amendment, which holds that if you had previously taken an oath to support the Constitution, which Trump did when he was president, and then you betray that oath by engaging in or giving aid and comfort to an insurrection, you are constitutionally ineligible to ever hold public office again. That's the argument. I find it persuasive. A lot of people do. The Colorado Supreme Court found it persuasive as well, that Trump engaged in insurrection on January 6, 2021, and therefore he can't be president again. Obviously, it was challenged. It went all the way up to the United States Supreme Court. And on the specific question of can states keep Donald Trump off the ballot, the answer was 9-0. So it wasn't just the 6 conservative justices that ruled in Trump's favor. It was even the 3 liberal justices as well. But then when you read past that, then there's some fascinating dissent, including potentially from a conservative Trump appointee. And this is where we need to break it down a bit. And then we'll get to the clips. We're going to skip to the very end of the per curiam opinion, which represents the anonymously written opinion of the majority. For the reasons given, responsibility for enforcing Section 3 against federal office holders and candidates rests with Congress and not the states. So note that, according to the majority, enforcing Section 3 against federal office holders and candidates rests with Congress, not the states. For this reason, the Colorado Supreme Court decision cannot stand. That's their argument. See how they did a bit of a carve out there? It wasn't just for any office holder, but for federal office holders. So according to the majority, Colorado could keep a Colorado government official off the ballot or take them out of office if they violated Section 3 of the 14th Amendment. So let's say you have a Colorado governor who engages in insurrection, then Colorado courts can kick that particular governor out of office or keep them off the ballot because they would have violated the Constitution. But states, the majority argues, cannot keep federal office holders, which is what the president is, right, out of office or off the ballot. That's the argument. Now, what's interesting is when you scroll past that, then we get to a comment or an excerpt from Justice Amy Coney Barrett, who was the final conservative appointee of Donald Trump, right, during an election year, I might add. So she issues this fascinating concurrence, and she says, listen, I join parts 1 and 2B of the court's opinion. I agree that states lack the power to enforce Section 3 against presidential candidates. That's what she says. That principle is sufficient to resolve this case, and I would decide no more than that, implying that this case goes much further than that, and it does, and we'll get to that in a second too. But she also says this: the majority's choice of a different path leaves the remaining justices with a choice of how to respond. In my judgment, this is not the time to amplify disagreement with stridency. The court has settled a politically charged issue in the volatile season of a presidential election. Particularly in the circumstance, writings on the court should not turn the national temperature, or should turn the national temperature down, not up. For present purposes, our differences are far less important than our unanimity. All 9 justices agree on the outcome of this case. That is the message Americans should take home. That is fascinating, folks, because I have always been led to believe, particularly by conservative, just conservatives in general, conservative lawyers, conservative judicial scholars, whatever, that the United States Supreme Court is never supposed to take politics into consideration when they give their opinion. And that opinion from Justice Barrett, these comments sound very political. Like, hey, listen, I agree with some of this. I think the court goes too far, but I'm not going to voice my disagreements with them now about it because this is so politically fraught and it's so polarized and we're just in dire times. So everyone should just kind of shut up and hold hands and, emphasize what we agree on. Fascinating stuff. Sounds like even conservative justices and judges like Coney Barrett are in fact political creatures after all, with political considerations. Fascinating stuff. She tells on herself. So then we get into a dissent from the 3 liberal justices, Kagan, Sotomayor, and Jackson, because even though they agree that Trump should be allowed to be on the ballot, at least that Colorado shouldn't be able to kick him off, they think the court goes too far. So this is what they have to say. In this case, the court must decide Whether Colorado may keep a presidential candidate off the ballot on the ground that he's an oath-breaking insurrectionist and thus disqualified from holding federal office. Allowing Colorado to do so, we would agree, create a chaotic state-by-state patchwork at odds with our nation's federalism principles. That's enough to resolve this case. Yet the majority goes further, okay? They decide a novel constitutional question to insulate this court and petitioner from future controversy. Although only an individual state's action is at issue here, the majority opines on which federal actors can enforce Section 3 and how they must do so. The majority announces that a disqualification for insurrection can occur only when Congress enacts a particular kind of legislation pursuant to Section 5 of the 14th Amendment. In doing so, the majority shuts the door on other potential means of federal enforcement. We cannot join an opinion that decides momentous and difficult issues unnecessarily, and therefore we concur only in the judgment. Folks, this is fascinating. Again, so when people tell you, oh, this was a 9-0 decision, it was a 9-0 decision only in as much as even the liberal judges agreed. Again, I disagree with them, but I'm not an attorney. I'm not a judge. I'm certainly not a Supreme Court justice. That Trump shouldn't be kicked off by Colorado based on what we have. But they said that the court overreached in its decision. So you see what I'm saying? You have some dissent, not just with the liberal judges or justices, but also with Justice Barrett as well, again, which betrays serious political considerations from a body that's supposed to be apolitical. That's what everybody claims. You're not supposed to take politics into consideration.